there are various criteria that USCIS will look at, such as evidence of high remuneration, or evidence of playing a critical role within an organization, or evidence of awards that this individual has received. And the list of criteria go on. The US immigration system has multiple ways for entrepreneurs to get immigration benefits to the United States. In this video, we're going to go over several of those options. So let's get started. The first option that I want to talk about is called International Entrepreneur Parole Program. What's unique about this option is that this is not a visa and it is not a green card. It is a period of authorized stay that is granted to certain people that have an ownership interest in a startup that has the potential for rapid growth and job creation. Now, there are several requirements associated with the International Entrepreneur Parole Program, but for the right candidate, this can be a great option to get immigration benefits to the United States to essentially be in the US and operate your company. The second option that I want to talk about is the E2 visa. I've talked about the E2 visa on many occasions because it is an extremely powerful immigration option. Basically, the E2 visa is a non-immigrant visa that allows somebody to get a visa to come to the United States and operate their own business in the United States. The main aspect of the E2 visa is that the individual that is applying for the E2 visa needs to make a substantial investment in a US business. Now, what is substantial? At our firm, we typically recommend at least $100,000 or more. And there's more that goes into it, but to simplify it, in many cases, investments of $100,000 or more will qualify. And we've had situations where investments for less than that have also qualified. And there's other requirements with the E2 visa as well, but I want to provide you with a general overview. Now, the third option that I want to talk about is the L1 visa. The L1 visa is also called the intra-company transferee visa. And this visa allows a foreign company to transfer certain employees to work for a related US company. So there's a foreign company and there's a US company. Those two companies need to have something called a qualifying relationship. So it can be a parent-subsidiary relationship. The two companies could potentially be affiliates of one another. One company can be a branch office of the other company. So there needs to be a qualifying relationship. And through the L1 visa, the foreign company can transfer a certain employee, assuming they meet the various requirements, to work for a related US company. Now, why is this such a tremendous option for entrepreneurs? Well, the L1 visa allows somebody, even if they are an owner of the foreign company or the US company, it can still allow that individual to transfer to the US company, assuming the requirements are met. In addition, let's say that the US company has not even been set up yet. There's a special subcategory of the L1 visa called an L1 new office petition. And this can allow the foreign company to transfer the employee to work for a brand new company within the United States that has a qualifying relationship with the foreign company, assuming all the requirements are met. So the L1 can also be a great option for entrepreneurs. Now, the fourth option that I want to talk about today is the O1 visa. The O1 visa is a non-immigrant visa for people that have an extraordinary ability in a particular field. One of the fields that is eligible for an O1 visa is business. So if an individual can demonstrate that they have an extraordinary ability in the field of business, and the various other requirements of the O1 visa are met, then the O1 could potentially be a suitable option for that individual. How does USCIS determine whether somebody has an extraordinary ability? Well, there are various criteria that USCIS will look at, such as evidence of high remuneration, or evidence of playing a critical role within an organization, or evidence of awards that this individual has received. And the list of criteria go on. So that's the O1 visa. Now, as I mentioned, the O1 is a non-immigrant visa. So it's temporary in nature and it doesn't lead to a green card direct. Another option, we'll call this option number 5 for entrepreneurs, is the EB1A visa option, which is an immigrant visa option similar to O1, But again, O1 is non-immigrant. EB1A is an immigrant classification, so it does result in a green card. The requirements between an O1 and EB1A are quite similar in the sense that EB1A is for people that have an extraordinary ability. But as you can imagine, because EB1A results in a greater immigration benefit, lawful permanent residence, and a green card, the standards for qualifying for an EB1A are heightened. And the level of scrutiny that an EB1A application will undergo is higher than that of an O1. And the thresholds to meet is even higher than that of an O1. And there's various other differences as well, but for purposes of this video, we'll leave it at that. Now, moving on to our next immigration option for entrepreneurs, the EB2 National Interest Waiver is for certain advanced degree professionals or people with an exceptional ability that can demonstrate that their field that they're going to be working in the United States has national importance, has substantial merit. Let's say that you're an individual that's operating some sort of a business that's in the space of clean energy. Or let's say you're an entrepreneur that's operating some sort of a pharmaceutical company that has very promising medical developments underway. These are examples of some potential cases that could qualify for an EB2 National Interest Waiver. Another example of an industry that could potentially qualify for an EB2 National Interest Waiver are certain aspects of AI development, artificial intelligence. In many cases, an entrepreneur operating in certain fields of AI can potentially qualify for an EB2 National Interest Waiver, assuming the various requirements are met. Final option that I want to talk about in today's video is the EB5 visa. Similar to the E2 visa that we talked about earlier in this video, the EB5 visa is also an investment-based visa. However, it's an immigrant visa classification, meaning that upon successful completion of the entire process, it can result in a green card, lawful permanent residence. Now, the basics of the EB5 program are that you have to make an investment and you have to create jobs for US workers. Now, currently, the absolute minimum investment amount required to qualify for EB5 is $800,000. And in some cases, the minimum investment amount could be $1,050,000, depending on where the business principally does business. So there you have it. We just covered 7 different options that could potentially work for entrepreneurs to get immigration benefits to the United States. I hope you found this video helpful. If you know anybody that can benefit from this information, please feel free to share this video with them. We're all about empowering you with knowledge. So the more people that can watch this video that can benefit from this information, the better. If you like this video, please smash that thumbs up button. When you hit that like button, it really helps for YouTube to know to share this information with more people. And if you haven't yet subscribed to our channel, make sure to hit that subscribe button. As always, thank you so much for tuning in, and I'll see you on the next video.